So welcome everyone. I'm Rafael Carmona from the ICDR, and as you probably know, I work also with our young practitioners group, ICDR Young and International, or Y&I. Before we begin the webinar, I want to first thank you all for attending today. Thank you to the panelists for speaking about the rules today. And I want to also take a moment to remind you that if you want to join as a Y&I associate, you can look for our website in Google. If you look for ICDR Y&I, you will find us online. You'll find our website where you'll see some registration forms in English and in Spanish. And you'll also see there are past webinars that we've recorded and uploaded there. In addition, you can also follow us in LinkedIn. There's a LinkedIn group. If you look for ICDR Young and International, you'll be able to find us, and you can request to join the group. We will also be posting all of our updates there. So without further ado, I leave the floor to Gretta so that she can proceed with the webinar.
Thanks so much, Rafa. And I'll just echo Rafael's welcomes and thank yous to the participants today as we look at the ICDR's revised rules that came into effect in March 1st of this year. We're going to take a deep dive into several of the key revisions today to discuss what changed, what didn't, how the changes compare to other rules, and how these changes might impact future ICDR practices and arbitrations. And we've got really a remarkable panel today to discuss these issues. First up, we have James Hosking, my colleague. James is a partner and co-founder of Chaffetz Lindsay in New York. He's duly licensed in New York and New Zealand and acts as counsel and arbitrator in arbitrations under the rules of all the major institutions, but most importantly for today's purposes, the ICDR as well. We also have Martin Gusy, a partner at K&L Gates in New York. He brings a unique perspective of being a dual licensed common law civil law attorney, being licensed in both New York and Germany. And Martin also brings the perspective of both counsel and arbitrator, again, under a broad range of rules, but again, most importantly, the ICDR rules for today's discussion. We also have Luis Martinez, who really needs no introduction, but I'll try to do so anyway. Luis is the vice president at the ICDR, where he directs the ICDR in the regions, including the East Coast of the United States, Central and South America, the Caribbean, and Spain and Portugal. He brings a tremendous amount of insight and experience, as many of you know. And I learned this morning, actually, in looking at his bio, he was the first attorney hired at the ICDR when it was created in 1996. So if anyone knows it, it's Luis. So with that, we have a lot to discuss today. But I think maybe a good place for us to start is by turning it over to Luis, just to understand a little bit about the context as to what it brought about these rules revisions and some of the key aspects from the institution's perspective. So Luis, could I pass it to you to get us started to understand a little bit more about the background of the rules and really some of the key provisions?
Absolutely, Greta, and thanks for the kind introduction. It's a pleasure to join you and Martin and James. I'm going to start off by touching upon the reasons for the rules revisions and some of the articles. This program is going to be distinguished by the fact that we will discuss the rules revision, but then the panel is going to take a real deep dive and discuss applications and practical considerations regarding a number of important rules in this actual revision that took effect on March 1st, 2021. I'll start off by just looking at the philosophies. You know, one of the things for us that we had to consider is really that we have users from all over the world. As you can see, this is from our 2020 caseload. We had parties from 100 countries participating in the ICDR system. So we really have to distinguish these rules. We are the international division of the American Arbitration Association. We are different from the commercial arbitration rules that the AAA uses. And there are international best practices, international expectations. And that's important why we have to keep sure that these rules really reflect international practice and expectations. So let's look at some of the philosophies behind it. The last revision prior to this one was 2014. We undertook the 2021 revision with really a number of the similar goals that we had for 2014. Certainly greater transparency. We needed to make sure that every administrative step the ICDR takes is reflected in the rules. It's our expectation that if a party reads and goes through the rules, they're going to understand fully what the administrator, what the ICDR is doing, and how their case will proceed from initiation to award. In the 2014 revision, we did not update the international mediation rules. So we decided that we would take a good look at those and see how they can be improved, what revisions were needed, what best practices, etc. And the same approach was taken with the arbitration rules. And then, of course, a goal that we had in both revisions was really process efficiencies, where we could reduce the time and costs of the ICDR system and give the parties the options that they could avail themselves as they draft their arbitration agreement or proceed through the arbitration process. So I'm going to start off and just say a few words about the mediation rule highlights. We did include express language that video, audio, and other electronic means can be used during a mediation. The previous mediation rules, as well as the arbitration rules, did not preclude their use, but definitely impacted by the COVID pandemic and the increase we're seeing in virtual hearings. We wanted to expressly include that in both the mediation and arbitration rules. We reframed the appointment language. We wanted to stress to the parties that we were going to be more proactive in assisting them in finding a mutually agreeable mediator. So we included that verbiage in that particular rule. And then we looked at the duties and responsibilities of the mediators so that we would clearly explain their role, how they're going to participate within that process, and clearly laid it out in the body of the mediation rules. Now, for process efficiencies, we included again and transparency that we will be conducting a preparatory conference with the mediator and the parties once appointed. We're going to be discussing technology, document exchange, the fact that ex parte meetings will be in fact occurring during the individual caucuses. So that's spelled out in the rules. And then another provision that applies to both the mediation and arbitration rules is a reference to the fact that the parties should be discussing cybersecurity, privacy, and data protection issues. We know we may be impacted by data protection laws in different jurisdictions, for example, the GDPR and the EU, etc. So that is an important point that mediators will have to discuss with the parties during that preparatory conference. And then priding ourselves on innovation, we included a new rule that M14, that termination of the mediation. It actually references the Singapore Convention. And the parties can actually request from the mediator or the ICDR to issue an attestation that the settlement was actually reached in the course of the mediation that may assist them with such enforcement. We're obviously aware that we still don't have the enabling legislation here in the United States and in many of the jurisdictions that have signed that treaty, but we wanted to get ahead of it, do our darndest to promote mediation. And we think this type of verbiage will help that. And we're hoping that this treaty has the same impact on mediation that the New York and Panama Conventions had on arbitration. So we'll keep our eyes peeled on that. The mediation rules, by the way, will apply. So the parties, in fact, have to opt out, and that is in the arbitration rules. So let me switch over to the arbitration rules highlights. Again, on the basis of transparency, this was one of the processes that we were administrative doing, was the fact on how we would handle challenges. We have a standing committee that meets weekly to discuss challenges. They may discuss issues such as the parties are not in agreement to the number of arbitrators. The parties may not agree on the seat. There may be some disagreement as to whether the filing requirements were formally complied with pursuant to the rules. All these decisions are submitted by the case manager They prepare the documents, we have comments from the parties, and then a standing committee of a former general counsel of the AAA ICDR and two ICDR executives get together, and we make these determinations. We try to be consistent. We apply the rules in a consistent fashion. We look at how we've handled these decisions historically, and I think it leads to a better quality and consistent manner in which these are handled. We have decided not to include the reasoning behind these decisions. Again, being sensitive to the fact that time and costs continue to be a concern for our users. If we had to stop and render the reasoning behind what is really an administrative determination just to comply with our mandate of getting that tribunal appointed, it's just going to add further delay and perhaps open our decisions to further attack and delay. So we just complete these, get them done, and keep the cases moving forward. As I mentioned, we did change the presumption, so parties will be required to mediate as part of the arbitration mechanism pursuant to Article 6. Now, they can opt out, so they will be given that opportunity, but otherwise, it's our presumption that we're going to mediate, and it's going to be done concurrently. We're not going to delay the arbitration. We're going to get the mediation up and running as we are proceeding with the arbitration agreement and the appointment mechanisms that are included in that arbitration agreement. Another revision, again, on the basis of transparency, has to do with the disclosures and our impartiality and independence. Martin and James will discuss some of that later on, but one of the things here for transparency is, as part of the appointment set of documents, the arbitrators are requested to comply with the AAA ABA Code of Ethics for Arbitrators in Commercial Disputes. So that verbiage was included in that article. And we have a new article dealing with tribunal secretaries. Again, recognizing that they are part of the international arbitration landscape, we wanted to consider how best they should be implemented. So this is a bit of a placeholder because we are now working with the ICDR guidelines that it references, and the rule says that a tribunal may, with the consent of the parties, appoint a secretary in accordance with the ICDR guidelines that are on the way. And some of the things we're dealing with is how the requests will be made. We're always worried about if the tribunal requests directly from the parties, they may be reluctant to upset the tribunal, and if they don't agree with them, how can they object to them? What are the disclosures needed by the tribunal secretaries regarding their impartiality and independence, how their compensation will be handled? Some of the issues that I've dealt with is what exactly is their role? They may be involved in some research. I've had some cases where that was in fact the case. And what we wanted to have is a disclosure exactly what type of research and how will that be handled so the parties can fully understand the role of that tribunal secretary. So I mentioned about the cybersecurity issue here as well, that we have an important milestone for us is our preparatory hearing, where once the arbitrators are appointed, they will have this conference with the parties to discuss issues such as cybersecurity, privacy, data protection. And really, that's such a milestone for us. It covers all the logistical and procedural framework of the arbitration once they actually are confirmed and the process is underway. Another rule is that we did change the presumption that unless otherwise agreed by the parties, evidence, witness testimony should be presented, it used to be may, in the form of written statements. We allowed for electronically signed orders or awards that can be used unless the law, the administrator provides otherwise. And then we continued, and this is verbiage that's unique to the international rules. You won't find it in the AAA's domestic rules, where, for example, the commercial rules are just deemed private. We were able in the 2014 version to publish awards that have become public in the course of enforcement. But here we added another component that we can publish awards unless a party objects within 6 months of the award being rendered. It's not going to be a gotcha moment. We're going to remind the parties at the beginning of the case. We're going to remind them when we transmit the award. So we want to make sure that they do have an opportunity to object. But we think that publishing more of these awards would be really very helpful to international arbitration. And then wrapping up, we increased the threshold. We didn't change much to our expedited procedures. They've been well received. We've had over 180 cases in the last 2 years pursuant to these mechanisms, but we increased the threshold to 500,000. They're really quite easy to follow. They're read in conjunction with the International Arbitration Rules, so their provisions will apply, and when they're silent, you look for the remaining provisions in the body of the regular rules. You can see the roadmap there, accelerated timeframes, detailed submission and filings. You can proceed on documents only. There is a presumption that if it's 100,000 or less, it will be documents only. If there's a hearing, which we didn't recommend before, but it's somewhat easier now with the virtual hearing options that have been developed. You can have a hearing, and then the award has a deadline within 30 days from the closing of the hearings or the last round of submissions. So these cases were roadmapped out to take place about 135 days. On average, we're seeing more than 200 to 210, but that's really because the parties do agree to extensions. And then concluding, we did not tweak the emergency measures of protection extensively because they've been doing so well over the years. We were the first institution to introduce this mechanism back in 2006. Now, all the institutions really are carrying access to an emergency arbitrator that they can seek emergency relief really upon the filing of the case. Even before the tribunal is appointed, you seek out the appointment of this emergency arbitrator. What we did tweak is we added some reasons as to why the parties, for example, they have to include why they're likely to be found entitled to such relief and what injury or prejudice the party will suffer if the relief is not provided. Otherwise, the rule really wasn't changed and it was doing extremely well. Just to give you an idea, you can see some of our stats, which this comes from our infographic from 2020, which lists our statistics, but we've had over 119 applications for emergency measures. You can see when they're granted in partially or full, 53 cases, denied 29 cases. Usually the reasons for denial is that they don't think it really is emergent and should be handled with the final award after the hearings on the merits have taken place. And you can see how some of them have been withdrawn. And now the AAA commercial rules, which by the way are used in international cases as well by party agreement, also offer an emergency arbitrator mechanism. So really that's the overview. I'd like to turn it back to Gretta then to continue with the deep dive on some of the remaining rules that I did not in fact cover. Gretta?
Thanks so much, Luis. Your presentation raised a lot of questions in my mind, and I'm sure from the audience as well, which reminded me I should mention that the Q&A function is open for the Zoom call today. So please feel free to put questions in there as they come up, and we'll try to take them as they go or get to them at the end once we get through the presentations. So the next segment of our presentation now is turning to really taking a deep dive at several specific rules revisions and tapping into James and Martin's extensive experience in doing so. And I should have mentioned at the start of the program, but one of the reasons why James and Martin are so well poised to share their insights and advice is that they're the co-authors of the textbook on the ICDR rules. They've written 2 editions now of a guide to the ICDR International Arbitration Rules that does exactly this. They take a deep dive with the rules and explains what it means. In addition, James was on the rules revision committee when the rules were revised last time around in 2014, and James and Martin are both on the ICDR publications committee that provided insights and comments on the draft revisions this time around. So between their experiences, they're certainly well suited to share their insights today. The first revision we wanted to tackle was that with respect to Article 8.1 and 8.9 of the rules covering joinder and consolidation. Under the new versions of the rules that went into effect earlier this year, the ICDR has now expanded the scope of when both of these are permitted. Specifically, joinder is now allowed in certain cases, even after the tribunal has been constituted. And with respect to consolidation, it's permitted where the parties involved are not only the same parties, which was the previous standard, but also if the parties are related parties. And James, I want to start with you on these revisions. As a practical matter, what does this really mean for joining parties after the tribunal has been constituted?
Well, thank you for the introduction, Gretta, and for your remarks, Luis. And I should say thank you to the ICDR and to ICDR Y&I for the invitation. And you wouldn't think it looking at Martin and me, but it wasn't that long ago when Martin and I actually were the co-chairs of the ICDR Y&I back when we were young and international, and in my case, slightly less gray-haired. So yeah, let me make a few comments about Article 8 and the revision, because it is an interesting one that really, I think, brings the ICDR rules into the best practices of other institutions. And then, as usual with the ICDR rules, they've gone a bit beyond that to try and introduce a new innovation. So if you're a claimant and you want to join an additional party, you do that when you file your notice of arbitration, and there's a very clear procedure for doing so. And if there's a question about whether that party is appropriate or not, then that gets dealt with by way of a jurisdictional objection or something similar. But the new rule revision addresses a situation where it's the period after any arbitrator is appointed, and where the claimant or the respondent seeks to join an additional party and that additional party consents to it. So it is the key distinction there is that at least an arbitrator has already been appointed. So let me make a couple of observations about how that works in practice. First of all, it is limited to the situation where one of the existing parties, the claimant or respondent, wishes to join the additional party. So it's not dealing with a pure intervener type action that you could do in a litigation context. Some sets of rules try to address that proposition. That's not what this revision addresses. Secondly, looking at the language of the provision, the party seeking the joinder submits to the ICDR a notice of arbitration against the additional party. It's an interesting choice of language there. It suggests that the applicant has a claim against the third party, but if you look at how that rule and very similar language has been interpreted elsewhere, it's not limited only to that situation. You might, as a claimant, when you see the respondent's counterclaims, decide that actually there's an additional party that should be joined in order to fully defend against the respondent's counterclaims. And the last point I'll make is that, again, looking at the language of the rule, the joinder application is subject to Article 13, so it brings in the appointment provisions in the rules, which, as I said, this arises where any arbitrator is appointed. So you might not yet have a fully constituted tribunal, and I'll make some comments on that later. And then secondly, it's also specifically subject to Article 21, the jurisdiction provision. So questions about whether the additional party is properly subject to the jurisdiction of the tribunal may be relevant to the application process, and for that you refer back to the language of Article 21 of the rules.
And James, what is your understanding as to how this plays out if the joinder is contested by one of the parties? Again, so sort of going back to that, what I just said about the nature of having any arbitrator appointed. If the full tribunal has not yet been constituted, then the administrator is going to have to play a role in making sure there is a tribunal constituted, because it's that tribunal that has the power under Article 8 to finally decide whether it's appropriate to join the party. And that may require the administrator using the stick of Article 13.5 of the rules, which says that if there are more than two parties, the administrator may appoint all the arbitrators unless the parties have agreed otherwise, no later than 45 days after commencement of the arbitration. So practically speaking, what happens is there's often an alignment of interest between one of the parties and the additional party, and you can see that they
may be treated, they may come to an agreement amongst themselves as to an arbitrator. If they don't, then the administrator has that stick of the potential for actually appointing all of the arbitrators. So that's the administration, the tribunal point. And then how do you deal with the application? Well, I've dealt with a few as arbitrator, and I've done a few as counsel. And so looking to the practice under other rules, and also what I would call general practice of international arbitration, you need to give the arbitrator needs to give the parties an opportunity to comment on the appropriateness of the application. That could be by way of written briefs. There may be a hearing. I've even had a situation where it was sufficiently contested where evidence was submitted as to the appropriateness of whether or not the additional party should be joined. So there needs to be a process in place for how to address the application. The second point I'll make on that is that there are, for example, in a non-signatory context, there may well be jurisdiction questions. And so the tribunal will have to work out, is this something that I look at in the context of the joinder application itself? Or do I do it in a two-step process, as is provided, for example, in the ICC rules, where the tribunal looks at whether there's a prima facie basis to have jurisdiction over the additional party, but then reserves the right to address jurisdiction either in a separate phase in the arbitration once the party's joined, or joining it to the merits, depending on the particular circumstances of the case. And the last point I'll make is that, ultimately, as I said, this is a light touch that the ICDR has taken. For those of you who went through the vis moot earlier this year, you'll recall the Swiss rules joined a provision which simply states that the arbitrators shall consider all relevant circumstances. So the ICDR has sort of taken a leaf out of that light touch approach and given the arbitrators a lot of discretion as to what comes within the context of what is appropriate. But I would suggest that if you look to the practice under other institutional rules, and I would say even under the practice under the international rules before they were amended, there are a few things that every tribunal should take into account. One is making sure that the additional party accepts the appointment of the tribunal. Two is that the parties still have an equal opportunity, and that the parties are treated equally, and there's a fair opportunity to present their case, drawing on the Article 22 Golden Rule. And lastly, but perhaps most important in the joinder context, that it will be an efficient process, that it will lead to expedition and avoid unnecessary delay and expense, which remains in the rules in Article 22, sub 2 and 8, and is going to be at the forefront of any discussion where you're joining an additional party.
Luis, I want to just ask you a question on joinder before we get James's views on consolidation. James raised some interesting issues that might come up on the administrative side in terms of joinder. How does the ICDR view what Article 8.1 does or does not do with respect to appointment of arbitrators from the administrative side?
Well, I think that's the key issue that we want to be clear on, is that if we are joining an additional party, did they have a meaningful opportunity to participate in the appointment of the tribunal? And if it's coming in after, obviously that wasn't a possibility, but as James mentioned, the arbitrators at that point would be clear to make sure that they accept the tribunal as appointed. We don't want to open up the award to further mischief down the road with the additional party saying they did not have an opportunity to participate in the appointment process. So, and if it's done before, obviously, we will make sure that they do have that opportunity, perhaps agreeing with the parties how the tribunal is going to be appointed, or in the worst case scenario, the rules do allow us, when there's multi-parties in place, to make all of the administrative appointments ourselves directly, something that we really don't like to do because obviously we want the parties to be comfortable and participate in the appointment process.
Thanks for that. James, maybe just briefly, if I can turn back to you on the consolidation revisions. Could you just give us a little bit more context as to what changed and how we could expect to see this play out?
Sure. Well, very briefly, the consolidation provision was extensively amended in 2014. The main innovation was the creation of a consolidation arbitrator who would have the role performed by the court or advisory body in other institutions, but here there would be an actual consolidation arbitrator appointed, and his or her job was only to deal with the consolidation question. And I understand that gets used rarely, but it has been used. The tweak that's been made this time around in the rules is a very subtle one. It's in Article 9(1)(c), where it's the residual provision as to when consolidation is appropriate. There's a 4-part test that is to be applied, and one of those limbs is where the arbitration involves the same parties. It said previously it's been amended to read the same or related parties, and that's to address a practical situation that arises where the second arbitration has been commenced under a different contract or under a different arbitration agreement, but it is related in some way. So, for example, if you look to the workings of other institutions who have used that or related language, the second arbitration could involve related parties who are related by corporate issues. It could be a parent or a subsidiary, or it could be related by a project or for contractual reasons like a contractor-subcontractor relationship. So it's a subtle but important broadening of the consolidation provisions.
Thanks, James. Again, I have a lot more questions that I'd love to get into now, but I also want to tap Martin's brain on some of the other revisions. The next topic we wanted to get into was with respect to third-party disclosures. Under Article 14.7, new language has been included into the rule, which now expressly authorizes arbitrators to order disclosure of third-party interest in the arbitration. And for those of you that haven't memorized the rules off the top of your head, Article 14 is the provision that deals with arbitrator independence and impartiality. So Martin, I wanted to get your views on what is the significance of this new provision in the fact that it's housed in the article concerning specifically arbitrator and independence and impartiality.
Thank you, Greta, and let me also start by saying thank you to Luis in particular and all of his colleagues at the ICDR that have supported the book projects over the years that James and I, and initially also Franz Schwarz, were involved in. And also a heartfelt thank you to Greta, who is mentioned in the second edition in our foreword, and James and I express our thanks for her contributions in the preparation of the second edition as well. And I should not be shy about it here either. Article 14.7 indeed safeguards independence and impartiality of arbitrators. And I think that's a very important placing within the rules in the application of the information that is now disclosable per se. One important word in Article 14.7 is may. It is still within the discretion of the tribunal to order the disclosure. It can be on the application of a party. It can also be on its own initiative. There's also something to be said on who the rule addresses. There are third-party funders and insurers mentioned, and that is in association with an undertaking to pay or to contribute to the costs of a party's participation. Important point here, third-party funders and insurers, and I'll get back to the insurers in a moment. The other groups of people that are addressed are just funders, no longer just the third-party funders, insurers, parent companies, and ultimate beneficial owners, all of which may have an economic interest in the outcome of the arbitration. Now, this addresses everyone involved in the arbitral process. The London market has reached out to me initially and reacted to the express mentioning of insurers. I think that's quite worthy of note here. Insurance contracts, the policies, of course, very often contain confidentiality provisions that may prohibit the disclosure of the existence even of a possible insurance coverage. Now, if indeed then an insurer, or let's say a party, is ordered to disclose the existence of an insurer that either pays or contributes to the costs of the arbitration, or even has an economic outcome. But I think it's more the first case that is relevant in practice, meaning that they actually did contribute to the financing of the arbitration. This poses a burden on the party that carries this insurance. And it's still, of course, a risk a party needs to assess carefully on whether it, on the one hand, may breach its confidentiality obligation towards the insurer, or it may breach its duty to disclose any circumstances that may, shed light, favorable light, on its position in the underlying arbitration. Article 14.5 says if you don't disclose, you waive any grounds for challenge on that. Now, that's probably not the real impact, but the other way around, everyone else involved in this arbitration in the end may be able to challenge the resulting award for a failure of the party to disclose insurance coverage. US litigators, of course, may be much more used to the requirement of having to disclose the existence of insurance. I mean, existence is the key word here. And reflecting that against Article 14.7, the tribunal here can even order the disclosure of the nature of the undertaking, not just the mere existence. So the long story short of Article 14.7, I think, is that it will have to play out in practice and could eventually lead to very broad disclosure applications by parties. That said, important again, Article 14.7 safeguards the impartiality and independence of arbitrators. So all of those serving as arbitrators and having an advisory role or even sitting on investment committees of third-party funders should watch out very carefully who's appearing in front of us.
Martin, you mentioned that it would go beyond really the scope of just independence and our impartiality considerations. Do you see that this revision might be something parties do as a tool for supporting the document request during the disclosure phase or other aspects of the arbitration then, as well?
I'd go for these purposes, primarily with the text of the rules, and Article 14.7 simply doesn't authorize these kind of, or support these kind of requests, because it simply safeguards the arbitrator's impartiality and independence, period. Now that said, there are the general provisions. What used to be Article 16 became Article 20 and is now Article 22 in the ICDR rules, giving every discretion to the tribunal to conduct the proceedings in a manner it sees fit. Look, again, I emphasize the word may even in Article 14.7. I think this is, again, an area where a balanced approach is needed. By the same token, the mere existence of a funder has most often, if structured appropriately in accordance with best practices, no impact on how a party conducts the arbitration.
Luis, before the rules revisions, were you seeing arbitrators requesting disclosures for third-party interest? Or was it something that you think the arbitrators felt constrained they didn't have the authority to do?
I really don't recall the issue coming up that frequently. I mean, there were some discussions and some issues that it was brought up during a preliminary hearing. And basically, it was known as well too if the third-party funder was there. But I think, this is really the idea that we want to just play it safe and clear the air. If there's an economic interest that should have been disclosed, we would hate for that disclosure not have been made and lead again to some problems later on at the enforcement stage.
Makes sense. So I hate to, I already threatened, I cut everyone off for the interest of time. So I will do so now and take us to the next topic on our list to cover. And that's the revisions to Article 21 of the rules, which covers arbitral tribunal jurisdiction. Already within the ICDR rules, there was, of course, the authority of the tribunal to decide on its own jurisdiction, and that included to decide matters related to validity, existence, things, the typical things that fall within the scope of the tribunal's competence. With the revisions from earlier this year, however, the language of that rule now also expressly includes that the tribunal is empowered to decide issues of arbitrability. And there's also an addition to the language that expressly states that the tribunal can decide all of these issues of jurisdiction without any need to refer such matters first to a court. And as far as I understand, this language is really unique to the ICDR rules, an innovation that they've adopted. So James, maybe kicking it back to you, can you share any insights on what prompted both of these changes, really?
Sure. Well, I can provide a little bit of insight from speaking to people and then who are directly involved in the amendment. I can also say that back in 2014, we looked at introducing something like this language. At that time, decided that it simply wasn't necessary. And at this point, I should probably briefly explain the background. I see we have some attendees from outside the US, so I will give the world's fastest introduction to the concept of competence as understood under the Federal Arbitration Act. And so basically, going back at least to 1995 and possibly further, the US Supreme Court has said that there's a presumption that gateway issues that include objections to jurisdiction are to be resolved by the courts, are presumptively to be resolved by the courts, unless there is clear and unmistakable evidence of an intention by the parties to an arbitration to delegate those issues to the tribunal. And that has spawned many, many cases. Last time I looked, there were over 500 citations to the main case in this area in federal courts on Westlaw, and a very strong body of case law. What's happened since 2014 that's prompted this change? Well, one thing is that more or less every circuit court in the US that has considered the issue has confirmed that where the parties in their arbitration agreement include reference to a set of institutional rules like the ICDR International Rules, that is clear and unmistakable evidence that those gateway issues are to be resolved by the tribunal rather than by the courts. That's the negative competence aspect, to use that terminology. So that's one thing. The rules have become very important. Secondly, and conversely, in 2019, when the US restatement on international commercial and investor-state arbitration came out, the reporter takes a different tack and suggests that institutional rules are not intended to have that negative competence aspect and exclude the court's jurisdiction. So there's a tension there, at least in the academic commentary. Given that background, it looks like it was decided to amend old Article 19 to include the two changes that you just outlined, Greta. And so it's really a clarification of what was already there, and an extra tool in the counsel's toolbox to try and have those sorts of gateway issues resolved before the arbitrator rather than the courts.
James, from an arbitrator perspective, do you see this really as an expansion of the rights or the authority you would have, or is this are these kind of just reinforcing what the types of issues that you would already consider under the ICDR rules?
So I guess it depends where I'm sitting. So in the US, I mean, this amendment, I will say, is clearly directed to trying to address the position under US law. So in the US, where the case law is strong but somewhat fluid, I think the language, like I said, gives you an extra tool as an arbitrator to say, no, this issue is to be resolved by me, rather than to use that language without any need to refer such matters first to the court. Again, that was probably the position before the amendment anyhow, but it makes it very clear. And then secondly, and arguably, the specific inclusion of the word arbitrability in the list of issues that are reserved for the tribunal first arguably expands what would have been in the old Article 19. That term arbitrability is a very freighted one that I used to tell my students to avoid using because it means different things in different places. But here it arguably that it picks up the language from the Supreme Court in some of the key cases like first options, where they have used a very broad definition of what constitutes arbitrability, and not just the narrow is the subject matter capable of being arbitrated definition, which tends to apply in some other jurisdictions. And then sort of put my hat on now and pretend I'm sitting in another jurisdiction outside the US. Does it move the needle in terms of competence? It's very hard to say. I mean, every jurisdiction deals with this particular division of power between the courts and the arbitrators differently, and uses a different test. I grew up in a model law jurisdiction where it was fairly clear all matters were for the arbitrators, but there was an immediate right to challenge that decision in court. Various, particularly civil law jurisdictions, there's no way that this language change is going to take away the court's power to hear a true issue about the existence or validity of an arbitration agreement. The fact that the parties entered into an agreement to that respect, including the arbitration rules of the ICDR, is not going to be enough. But I think it will introduce a certain amount of wiggle room, I guess, for a counsel who wants to try and make that argument outside the US. But I'd say it's probably going to have a limited impact.
Luis, prior to this revision, were you seeing parties in their arbitration clauses or any other way trying to overcome this first option presumption beyond just incorporating the rules, or was it the rules and they were hoping that was enough, really?
Yeah, I think the rules were enough, but again, with the restatement position, which we know is contrary to the case law for the US jurisdiction, we just wanted to play it safe and see what the institution could do to try to make it clearer. And we'll see if the Supreme Court ever clears this up on what really constitutes a clear and unmistakable delegation of that authority. But at least the rules do add this additional verbiage, which I think, as James mentioned, adds further support to the proposition that it's the tribunal who can handle these issues.
Maybe we'll just take one question before we're moving on to the next topic. We have a question. Are the revisions to Article 21 meant to influence the US court standard of review of a tribunal's jurisdiction? And maybe I'll just add on, in addition to whether they're meant to influence, maybe just your reflections or reactions as to whether they might or could influence that standard that they're looking at. And James, I don't know if you have views, or Luis or Martin. I know you've all discussed this and thought about this revision a lot, so I'll just open it up.
I mean, I see the question. Thank you, Steve. I mean, whether it was intended to have an influence on the standard of review, I'm not sure, but I don't see it really having that impact. An arbitrator's jurisdictional decision is subject to de novo review before the courts, and I don't think that can be changed merely by amending the rules or amending the parties' agreement.
I'd like to add one aspect of this, and I think if I'm well informed, the only justice on the Supreme Court that ever posed questions in hearings where first options was discussed, ironically or historically speaking, was Ruth Bader Ginsburg. Now that said, we shall see how this court, rules on any of those questions, if it ever rules on it. I mean, the Schein case is in front of it. But the indirect answer, Steve, I think, is the ICDR is indeed an institution that takes its mandate to influence best practices by means of rules changes. And I think that message will also be heard by the Supreme Court.
So this raises so many questions, but let's move on to our next topic, and that's with respect to early disposition. Article 23 in the revised rules is a brand new provision introduced in March of this year, and the provision now expressly authorizes for the early disposition of issues in advance of the merits hearings, in accordance with some provisions and caveats within that new provision. Martin, I'll pass the ball back to you. Could you maybe just start by walking us through the procedure that Article 3023 envisions for an early disposition?
Yes, thank you. And I think the emphasis is also on early disposition as opposed to denials based on manifest lack of legal merit. But I'll get to that at a later point in time. So the process is a dual-step process. Parties asking for dispositive relief will first have to ask for leave to do so. And once granted leave, then the motion can be submitted and there will be argument, at least both, well, all sides, I should say, not only both, will be heard on both steps of the process. So that's the process in a nutshell, something that's not surprising for US litigators. I think it was first in individual judges' rules that the so-called three-letter rule surfaced that, you had to, apply for leave to make certain motions in federal court. A practice that led to at least counsel being encouraged to simply state its requested relief on 3 pages only. Now, I hope that parties will be mindful of first having to have leave before actually submitting the application.
Martin, how does this, in your view, add to the authority that the tribunal previously had to resolve preliminary issues or in a bifurcated way?
I think it is helpful because one of the concerns tribunals have had and one of the ways out not to actually administer dispositive relief as part of the arbitral process prior to a full hearing on the merits was that the rules did not expressly authorize it. And that is the ICDR rules, one should say. There are, of course, other ways to, in the past also have blessed dispositive relief. I mean, there's again, the general provision, now Article 22, formerly 20 and formerly 16, that already, authorizes 2 things, ruling on preliminary issues, much so on point, and bifurcation, which, I think has been characterized as the acceptable face of disposition. Judith Gill needs to be given credit here. Now, that all said, I think it's worth looking back into US practice and then mirroring this onto international practice because the AAA commercial rules have long authorized in their Article 33 a similar approach, which was also a dual process, asking for leave and then application. There's Third Circuit precedent back in 2008 blessing summary judgment on this. So in the US, it's not only denials, and I want to make this point loud and clear. I think the ICDR here, again, took an approach that is broader than what other institutions have done. Couched in denial language approaches, I think arguably started with ICSID introducing its Article 41.5 in 2006. An investor's, a claimant's request for arbitration could be dismissed for lack of legal merit. Now, noticeably, nobody, I think, to my knowledge, has put the not so controversial situation of a case having lapsed, meaning the statute of limitations has run into writing. Now that's perhaps the most uncontroversial scenario where early disposition can be agreed upon, especially to the international practitioners not used to US disclosure or discovery practices. I think early applications do have their place because they can severely limit the necessary document productions resulting in cases. Of course, that's partial relief most often because once you get to disclosure, there's something left to be decided. Now that all said, the institutions around the world have added language allowing early denials. I mentioned ICSID. SEAC was second, I think, 2016. The SCC, followed 2017. CTAC, the Hong Kong rules were changed. For that matter, the LCIA rules, of course, Article 22 were most recently changed, and the ICC, authorizes these kind of applications by means of its practice note, not expressly in the rules. So I think it's uncontroversial that early dispositive relief should be available, but I applaud, the broader language here, not limiting it to denials. And again, as always, every tribunal, is encouraged to balance the interests carefully and sometimes also take a deep dive into especially well-pled cases. I think this is a key point here. I mean, if you are looking for early dispositive relief, then you need to have done your work as counsel early to make your case early on. The ICDR rules now, strongly encourage you to put witness statements in. I mean, that is most often constituted as direct testimony. There are certain jurisdictions, German jurisdiction needs to be mentioned here, where judges just comb through the pleadings of all parties and determine whether there's even an open issue of fact that merits entering the evidentiary phase. I don't see why that should not be done in an international arbitration if there's capable counsel, and counsel obviously has been told and warned that the pleadings submitted have more meaning than in a civil litigation.
Martin, I think the German perspective is an interesting one, and it taps on one of the questions that we've received that I'll put to both you and James. And that's, if you're sitting as an arbitrator and you get an application for one of these early disposition applications, what are you considering in deciding whether to grant it or not? Is it, maybe from a US perspective, is it that it's kind of akin to a motion to dismiss, or is it really the efficiency prong aspect? What is it as an arbitrator that you're considering either, or you would consider under the ICDR rules, or if you've had this under other rules as well?
Well, I would start with the heading efficiency gained versus efficiency waned, because this is really what this is all about. If you rule on summary judgment, and I want to emphasize again summary judgment here, not a dismissal. And the resulting procedure is that the award will be challenged and even overturned, then what you thought was efficiency gained is easily turning into efficiency waned. Now, that all said, I think counsel needs to be reminded, and this is important as an arbitrator, that there is not the safeguard of a hearing on the merits in every case.
If I can add one thing in answer to your question, Greta, my practice as arbitrator is, it's a key issue here, is what is the standard to be applied? And so I will, in the face of such an application, try and have the parties agree on the ground rules as to what test should be applied. Because it doesn't, counsel reach for what they're most familiar with, but the summary judgment rules as applied in federal court don't lend themselves particularly well in all circumstances to arbitration. And with international parties, you end up with parties just talking past each other. So it's fundamental in any application to be very clear on what test will be applied, and that includes burden of proof and other issues that impact on it. And so that's and I applaud the ICDR for the innovation here and the light touch. They've left it to the tribunal and the parties to fashion their own mechanism. It just, you have to be very clear on what that how that mechanism works and what the test to be applied is.
And Luis, maybe just before we leave this topic to move on to the next one, before the rules revision, how often was the ICDR seeing some sort of bifurcation or early resolution of issues? Was this something that you were seeing but felt like you needed more guidance and instruction or authority for the tribunal on?
We were seeing the requests. It was certainly something that we felt the users were looking for. As you know, I had mentioned we do administer cases pursuant to the commercial rules, and we saw the invocation of the article that they have for dispositive motions, which is another reason we thought it would be worthwhile to include it here under the international rules. But as mentioned, this wasn't precluded in the previous version without this article either. There was no prohibition to making those sorts of submissions. But we felt it was time to include it in these rules.
Well, it sounds like from Martin and James's comment, it's a welcome addition. So taking us to our next topic, and I'm going to kick it back to James now, so be ready with my question. And that's with technology and remote hearings. There were a number of revisions in the new rules concerning the use of technology and remote hearings. For example, Article 22 expressly directs the parties in tribunal to consider how technology can increase efficiency in the arbitration. Article 26 explicitly provides that a hearing can be held by video, audio, or other electronic means, whether by party agreement or tribunal order. Article 22.3 directs the tribunal to discuss cybersecurity, privacy, and data protection issues with the parties at the preliminary conference. And this is just a few of the innovations and revisions that the ICDR introduced with the revisions in March. James, if I could, my question to you is, could you maybe in your view explain really what some of these changes are? You know, from a, if you're not immersed in the rules, it might seem like some of these things were already involved. I mean, we all know that the ICDR, you could have remote hearings under the previous versions of the rules. So what do these revisions do, or what tools do they give you as both counsel and arbitrator to better address some of the issues that we've all been living during the last 16 months?
Well, let me answer that by setting the scene that probably many of our participants already know. I mean, as you said, Greta, you know, for the last 14, 15 months, we've all been dealing with the use of exactly this kind of technology in our everyday practice. I'd see the AAA ICDR has released statistics showing that in the March 2020 to April 2021 timeframe, they handled 5,902 cases that involved a virtual event, which is defined to include anything that includes a remote hearing of some sort, be it a preliminary hearing, evidentiary hearing, or something else. So, you know, this is part of our practice, and I think actually, you know, it's a credit to the ICDR and to the 2014 amendments that there really has been very little debate about the tribunal's authority to hold those kinds of hearings. There were innovations back then in what was Article 22, referring to the use of electronic communications, reflecting the reality of electronic filings and that kind of thing. And Article 23.5, sub 5, the tribunal may direct that the witness may be examined through means that do not require their physical presence, which was a variation on the amendment to the ICDR Rules that came into effect in 2010. And even in the expedited rules that contemplated a fully electronic hearing as part of the expedited rule provision. So the scene had really been set back in 2014, and I see these updates as really being reflecting, you know, the new reality and bringing the language up to date and in line with the very important protocols and practice notes that have been issued by the AAA ICDR and others. You know, other institutions have sort of been starting from a few steps behind in that respect, but this really brings the ICDR International Rules language into line with those other international institutions and with reality. I think the practical impact, to go to your question, is threefold. First of all, it's educating parties about the electronic options and encouraging them to make early decisions about how those electronic options will be used. And again, that was being done in practice, but now it's in the rules, so you're required or strongly encouraged to address it early in the process. Secondly, granting the arbitral tribunal broad authority to address technology within the rules, and it was already there, but this is now a very clear, even clearer mandate. And thirdly, protecting the award that is the product of a hearing that uses electronic means, you know, in those very few cases to date where an award has been challenged on the basis of not having a fair opportunity to present one's case, that type of argument. When you can point to a party agreement incorporating the rules where these types of technologies are specifically incorporated, that argument doesn't really have legs. And I'll just, you know, expand on that very briefly. I'm one of the co-editors of the ICA report into the question of whether there's a right to a physical hearing as opposed to remote hearing. And actually today, as we speak, the last of our 77 country reports is being put up on the ICA website, where we have had country reporters analyze how remote hearings are dealt with under the lex arbitri of each of those jurisdictions. And without wishing to spoil the conclusions that will come out in our report in a couple of months, there are jurisdictions where one has to be particularly careful about there being a party agreement to avoid what in some cases is seen as a right to physically confront a witness or to appear physically before your decision maker. And here the ICDR's revisions make very clear that the parties have agreed otherwise, and a careful arbitrator will incorporate that agreement into procedural orders, and that's really the key to making sure that the resulting award is enforceable. So I see the revisions as being a helpful updating to reflect reality, building on the work that was done in the 2014 rules.
Maybe just before we leave this topic, Luis, a brief question to you. Is the ICDR still seeing party objections to remote hearings, or is this something that parties are more willing to accept as a reality 14, 15 months in now?
I still see parties accepting this more readily now. In fact, on the graph on the charts that are being tracked at the virtual hearing site, you will see it escalating, that more and more as we proceeded through the pandemic, we're agreeing to accept the use of virtual hearings. What remains to be seen how it will play out once we exit the pandemic with greater numbers. I do think that in the larger cases, we will see the return to hearings in person, but certainly for procedural components and for other components internationally, I think they're here to stay.
So with that, I will take us to the last topic we have, and I've said in the chat, we've been incorporating questions as we go. We're still on time to finish on time, but I don't want to discourage anyone to please keep putting questions in the Q&A if anything comes up in that I can ask for James, Martin, and Luis to reflect on. With the last topic that we have for the agenda is deposits, separate awards. And Martin, I'm going to start with you on this one. Article 39.4 of the ICDR rules now expressly authorizes a tribunal to make a separate award for fees that one party pays in advance on behalf of another party. Now, Martin, maybe just briefly, looking at the language of the rules, do you see any challenges or things that parties should specifically bear in mind if they're asking a tribunal to grant it such an award under this new provision?
To me, reading this one sentence that got added in Article 39.4 is almost a no hiccup read. Now, I love the word may. I've said this before, and this is also contained in Article 39.4, and I think for good reason. And I'll be brief, but what sounds so benign, almost absolutely fair, depending on the extreme circumstances of cases, is not fair. The irony of this language is that, if you have multiple parties on one side and only, 2 of the 5, say, actually contribute to the paying of that side's share, those 2 parties could ask for an award against the other 3. That might be more theoretical, obviously, but you never know. There are circumstances where even, parties grouped in arbitration could have very different interests beyond this one arbitration. Now, that said, this principle of each side bears half of the costs in terms of the advances, obviously, subject to the allocation of the costs in the award in the end. It can by itself, in extreme circumstances, be quite a financing burden. I mean, there are cases where this could be a 7-digit sum of money. Clients are not at ease to just, ploy them out. Now, that said, if one side admitted to the other that, it may have a case on the merits, but it hasn't even thought about damages, I don't know how my client would react, having to advance half of the fees. Now, that all said, the ICDR system, obviously, thankfully for all of us, arbitrator operates on hourly charges. And it is not always that easy to allocate, the share of the burden of the tribunal to claims and counterclaims the way they are phrased. It could be as simple as essentially a set-off being turned into a counterclaim, or even a mere defense turned into a counterclaim. It could be an entirely separate set of facts and legal theory underlying such counterclaims. My last point before running out of time is, the ad valorem approach obviously, factors into the administrative fees in the ICDR system, not the arbitrator's fees. But in other rules, primarily the ICC rules, this is the case for the tribunal's compensation as well. And believe it or not, there can be severe battles about things like separate advances for claims and counterclaims. Now, my understanding is that the ICDR, and Luis reminded me about this, raises the financing of the proceedings on the administrative conference call. Another ICDR practice that needs to be applauded. It's an early reminder for everyone involved to really deal with the organization of the proceedings, which is different than institutions do. Now, of course, in an ideal world, we all agree on advancing the costs as long as the proceedings are ongoing, and then having the tribunal allocate it. But I do want to mention that if substantial amounts are at stake, if the legal merits are anything but clear, if multiple parties are involved, this humble language there that you can get an award for having substituted for the other side can turn out to be a very tricky thing.
And the tricky thing is depending on the jurisdiction, whether you can enforce that award immediately or you're just holding it for the time being. And many on the call will know, at least in the US, you can enforce interim awards. So maybe, but I don't know if this would qualify, right? So maybe that's a whole nother panel that will get you all back in to analyze. Maybe Luis, just with the 1 minute we have left for the operative panel, and again, if there's any final questions, please get them in now. How is it possible to share how often you see that a party fails to pay its share of the cost in ICDR arbitrations, and more broadly under the other rules as well, if you know?
I don't think it's a problem that plagues it. Obviously, the parties went into this agreeing to arbitration, understanding that the fees would be shared equally, but it does happen. I have a number of cases right now where this is the particular problem that's going forward. And the other component of that rule is that a party that is not paying their share, their claims are deemed withdrawn. So the paying party, in one case I have the respondent who's paying, has made that clear, has brought that to the attention, that rule to the tribunal, and they'll advance the costs because also strategically it helps because the other side's claims are deemed withdrawn. But having said that, it doesn't plague, it doesn't recur, it doesn't happen often, but it does happen.
Yeah. And the strategy decision both you and Martin touched on, it is a big one. I think we've probably all had conversations with clients where the other side hasn't paid, whether they want to take the financial burden up front to keep going on with the case or what it looks like for the case going forward. So there's certainly a lot to consider there. So with that, we've reached the end of our allotted time. And I know there's many more questions, but I'd encourage you to reach out to James, Martin, and Luis. I'm putting them all on the spot, saying they'd be happy to talk to you further about the revisions. But I want to thank James, Martin, and Luis for their time. Thanks for the assistance to Raphael for helping organize today. I think this has been a tremendously insightful panel, and to get all your views from both counsel, arbitrator, and institutional perspective in a deeper dive of some of these provisions has been very helpful, and I think raised a lot more questions and thoughts in my mind, at least. So I'll be interested to see how these play out going forward and how the ICDR practices keep developing. But thank you all for the wonderful insights today. And I look forward to the next one, hopefully being in person.
Thank you. Thank you, Greta. Thank you all.
Thank you.
Thanks.
Take care, everybody.